Good afternoon, everyone. Thank you for joining our monthly continuing legal education program. My name is Kristen Solis. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program, or DVAP, as we affectionately call ourselves. For those of you that are not familiar with DVAP, we are a joint program with Legal Aid of Northwest Texas and the Dallas Bar Association, and our primary mission is to match low-income Dallas residents with private attorneys that will work their civil case pro bono from start to finish. We take a wide variety of civil cases ranging from divorces, probates, expunctions, consumer issues, and we get a lot of landlord-tenant issues ranging from eviction issues to people needing their security deposit returned or needing repairs on their units. So today we are blessed to have Marianne Danello speak to us. She is the supervising attorney for the Dallas Housing Consumer Protection and Economic Benefits Division of Legal Aid of Northwest Texas. She got her JD from SMU and she joined Legal Aid back in 2005, and her practice was focused on the areas of housing, public benefits, representing tenants and homeowners with their housing issues, with an effort to prevent homelessness and to preserve title. And she also has represented individuals on economic benefits issues with SSI, SSDI, Medicaid programs, SNAP, unemployment compensation, and various other elder and probate issues. She is an expert on landlord-tenant issues. And as we go along, if you have questions, if you'll put them in the Q&A at the bottom, and Marianne will get to those as we have time at the end of the program. So without further ado, I will turn it over to Marianne. I think we just lost your sound.
Hello?
Okay, I can hear you now.
Okay, sorry. All right, so I was just saying hello and thank you to Kristen for the lovely introduction. As Kristen noted, I will be taking questions at the end of the presentation. Also, I have provided DVAP with the PowerPoint, so you should get an email after the presentation with a copy of the PowerPoint and my contact information, should we not get to, the questions at the end, but hopefully we will. Okay, so let's get into it. Landlord tenant law, evictions, and common issues. So this is the outline of the presentation today. We're going to first talk about the landlord tenant relationship. Then we'll go over the eviction process, briefly mention the CARES Act. We'll discuss lockouts, interruption of or termination of utilities by landlords, repairs, landlord liens. We'll discuss domestic violence in the landlord-tenant context, reasonable accommodations, and very briefly on federally subsidized housing. Okay, so the very first thing that we need to determine is, does a landlord-tenant relationship exist? Now, if there is a written lease, we're done. The parties have clearly decided to enter into a landlord-tenant relationship. If there is no written lease, then the attorney does need to take a moment before jumping in and analyze whether or not a landlord-tenant relationship exists. Oral leases are valid in the state of Texas as long as they don't violate the statute of fraud. So you can have an oral agreement. But if it's not clear, it's important that we know that the payment of rent itself, and I put rent in quotations there, is not dispositive on whether or not there's a landlord-tenant relationship. So in Texas, case law says that a relationship exists when both parties intended to establish such a relationship and the owner lessee has transferred, and this is key, exclusive possessory rights of some or all of the residents. And courts evaluate this relationship as a question of fact and look to the interaction between the parties to determine the relationship. So if there's not a landlord-tenant relationship, then the eviction process is not needed. And I put on here, Auntie M does not need to evict Dorothy. And I wanted to use that as an example. So most of us have heard the story of the Wizard of Oz. But Dorothy in The Wizard of Oz is a young girl that's being taken off to Oz. But in this scenario, Dorothy is now an adult, but she is still living with Auntie M. But it's reached a point where Dorothy is hanging around with some not too savory characters. And the Tin Man and the Cowardly Lion, they've stayed back in Oz, but Dorothy is now hanging out with a group that just makes Auntie M uncomfortable. And they're throwing parties at Auntie M's house. There may be some drugs involved. Auntie M has noticed that money is missing from her wallet. Valuables are disappearing in the home, and Auntie M wants Dorothy out. Does she have to evict her? No, because while Dorothy is simply an adult living with Auntie M has not granted Dorothy the exclusive possessory rights of all or some of the residents. So Dorothy is not a tenant. Just like boyfriends, girlfriends living together, there is not a landlord-tenant relationship. So if one of them owns the property and their boyfriend or girlfriend is living with them, even if they are contributing to the mortgage or paying the utilities, or maybe they buy all of the groceries, that is not rent necessarily. They own the property. The individual is a guest or invitee, and they do not need to go through the eviction process. Or I should actually say, should not need to go through the eviction process. And the reason I say should not is because while legally speaking, the owner of the home, in this case, Auntie M, should be able to tell Dorothy, look, you need to find some place to live. And if you don't, I'm just going to change the locks. And as long as Auntie M provides Dorothy with access to her belongings, so she's not guilty of conversion, that should be the end of it. And if Dorothy calls the police and says, hey, Auntie M locked me out, the police should tell her that she needs to leave or be arrested for trespassing. And if Dorothy thinks that a landlord-tenant relationship has been established, that she can go file for a writ of reentry. And we're going to talk about that later in the presentation. That's what should happen. And the unfortunate reality is, especially in Dallas County, is that the police, rather than telling them to go get a writ of reentry, often will force Auntie M to unlock the door, let Dorothy in, and tell Auntie M she needs to evict Dorothy, which is completely incorrect. And the police are putting themselves in the role of the justice of the peace, who is the one who has the authority with a writ of reentry to determine whether or not a landlord-tenant relationship exists. So I said, we'll talk more about that later. I did want to mention motel and hotel guests because we see this a lot. Most of the time, motels and hotels are very careful not to create a landlord-tenant relationship, and it is a guest or invitee. There is, however, an argument to be made. So when we're looking at a lease agreement, we're looking, is there a fixed term tenancy or a tenancy at will? A tenancy at will is one where where there is a landlord-tenant relationship, but there are not specific terms of the tenancy. So this could be verbal agreements to let a friend or family member stay. It's possible you created a tenancy was created at will if, again, exclusive use and possession was granted to that. Periodic tenancies are month to month. They can also be week to week. The period is actually determined by the frequency of rent. If there's no lease agreement, title sometimes can be at issue. If title is at issue, an eviction suit cannot proceed. Eviction suits, original jurisdiction is with the Justice of the Peace courts, and they do not have jurisdiction over title. So if title is at issue, it cannot proceed. If the tenant did not get a complete copy of the lease agreement, then an eviction suit can be abated if the landlord does not provide them a copy, with the exception of non-payment of rent cases. We'll talk about that in a moment too. But let's get back to the hotels, motels. I said we would dig a little bit deeper into this. I'm going to go through these slides fairly quickly, but I wanted to make clear that the general rule is a hotel guest is not a tenant. So the eviction procedure does not apply. And the hotel or the motel is allowed to use peaceful self-help to remove the guest, including changing the locks and removing the guest's property. Typically, what they do is they move the guest's property into a closet that is often in the lobby and let the guest know, here's your property, you can take it, but we're no longer going to allow you to stay here. Big exception to the rule. If an individual has lived at a motel for months or years and pays rent monthly, they may, and I stress may, have established a monthly tenancy requiring the owner to use the eviction process. Again, this is determined on a case-by-case basis, and in the absence of a written lease, it is not decisive. The length of stay, the frequency of the payments, what services are or are not provided, receipt of mail, all of this kind of factor into the equation. So hotel guests don't have any protection from eviction or lockout by the owners because there's no judicial process unless they've established that tenancy. So how do you establish a tenancy and what is the recourse if they're locked out? Well, if an individual has been locked out of a motel and believes they've established a tenancy, they can call the police and explain, hey, I'm a tenant, I'm not merely a guest, and ask the officer to tell the owner to use the eviction process. This sometimes works. It works more with homeowners than it does with hotels and motels. The police are more likely to tell a hotel guest you're not a tenant than they are to tell someone who is living in a home that they are and making that judgment call. If the officer says no, they shouldn't argue with the officer, but go to the Justice of the Peace in the precinct in which the property is located, and they file a sworn application for a writ of reentry. Writ of reentries are very quick, and they're usually heard the same day or within the next business day. If the Justice of the Peace decides there is a tenancy, and they may have this hearing on an ex parte basis, if they can't get a hold of a representative for the hotel right away. If they do issue a writ of reentry, then the owner is going to have to follow the eviction process. This is fairly rare, though, especially in Dallas. So here's some of the case law. A hotel and guests do not have a landlord-tenant relationship. Therefore, hotel owners are not required to file an eviction lawsuit and may forcibly remove the guests, provided no more force than unnecessary is used. However, we also want to see that in this particular case, which is Ollie versus HVM, the hotel filed an eviction lawsuit to evict an extended stay guest. The appellate court noted that no landlord-tenant relationship exists between a hotel and guest. However, they specifically recognized that there are some appellate courts, and we'll see that in a moment, that have held without a landlord-tenant relationship. The Justice Court lacks jurisdiction, but explained that that's just one of the elements of a forcible detainer lawsuit. And it noted that in this particular case, Mr. Ollie had not complained about the trial court's conclusion of law that no landlord-tenant relationship existed, so they didn't explore it further. We've got some more case law here in Warehouse Partners versus Gardner, and this was a Dallas appellate case in which the court held that where an individual who had lived at the leased space for 2 years established it as his permanent residence, and therefore it met the definition of a dwelling under section 92.001 of the property code, and that the trial court had properly granted a writ of reentry. So the trial court found there was a landlord-tenant relationship and went ahead and granted it. One of the other arguments that I frequently see that people use is the Texas tax code. And this particular section of the tax code says, and it's a definition of a hotel for purposes of a hotel occupancy tax. So anyone who stays in a hotel for more than 30 consecutive days is considered a permanent resident under the tax code. And I really want to note, and I put this in red, I would not rely on the mere establishment of a permanent residency under the tax code as sufficient alone to establish a tenancy. You really need to look at other factors if you're going to bring this argument. The problem here with most of these arguments is they take place after, in many cases, the tenant has been dispossessed or the guest has been dispossessed of the hotel room or motel room where they were staying. So it's very difficult to do this in that when you're advising someone, you need to tell them that the presumption is that no landlord-tenant relationship exists. If they think there is one and they're dispossessed of the dwelling, they can request a writ of reentry. But if it's not granted, then they really don't have any recourse there, unless, again, they take that writ of reentry on a de novo up to county court and then the appellate. So I caution you to really let those motel and hotel guests know that when they're asked to leave, generally speaking, in Dallas County, they really do need to find another place to locate before they're relocate to before they're locked out, because we're really not seeing many justices of the peace willing to enter writs of reentry for hotel and motel guests. All right, so let's talk about the eviction suit, which more formally and correctly is called forcible entry and detainer, or the FED lawsuit. So here's our overall process of the lawsuit. So first, the tenant violates the lease or holds over on the lease term after being given notice by the landlord that they're not renewing. The first step in the process is a notice to vacate. Often tenants will come to us and they say, I've been evicted, when all they've received is a notice to vacate. So you want to make sure that you reassure tenants when they've got the notice to vacate that that is just the first step in the process. Now, when a tenant receives a notice to vacate, they have a decision to make. The first decision they can do is they can go ahead and vacate by the time that the landlord has given them. If they do that, it's important that the tenant understands that that notice to vacate does not terminate their liability on the existing lease. So they remain liable for the remainder of the lease, but they don't get to argue about it later if they simply choose to vacate. The other option a tenant has when they get a notice to vacate is to go talk to the landlord and see if they can work something out. Maybe that involves them leaving, but hopefully they can get a release of liability from the landlord. And option number 3 is they stay beyond the notice deadline and they plan to duke it out in the justice court. So tenant remains, the landlord then files a petition for eviction in the justice court. The landlord gets a trial date, the citation issues. Eviction trial in the justice court will happen within 10 to 21 days. The only issues are possession and rent. If the landlord obtains an eviction judgment for possession, the tenant has 5 calendar days to file an appeal to the county court, or the landlord can obtain a writ of possession, which the constable will enforce. So let's get into the details. Step 1, violation of the lease. Now, this could be non-payment of rent and everything else, all other possible lease violations. Non-payment of rent, this is a really harsh, I guess is the best word to say, in Texas. Okay. And I've put in here day late or a dollar short. There is no substantive defense to a non-payment of rent eviction if the tenant did not pay in full and on time. And it's important that we counsel tenants that the grace period, the end of the grace period, is not their due date. So often a tenant will tell me, my rent is due on the 3rd, or my rent is due on the 5th. But if you look at the lease contract, their rent is due on the 1st. And that is not considered, they don't have to pay late fees until the 3rd or the 5th, but it is late if they pay any day after the due date. Now, why is this significant? Because evicting a tenant for non-payment of rent is the easiest way to evict a tenant because there is no substantive defense to non-payment. And in Texas, the only time a landlord is required by law to accept rent from the tenant is when the tenant tenders it on time and in full, which is typically the 1st of the month. So the landlord does indeed have the right to reject rent that is tendered in the grace period. So between that, the 2nd and the 5th, because it's either the 3rd or the 5th that is that grace period, the landlord can reject it. Some of you may be thinking, well, why would the landlord reject the tender of rent during the grace period? Well, because it is so easy to evict a tenant for non-payment of rent, it's not as easy to evict a tenant for other rent breaches. And this may be, in one area we see this a lot in, is with senior citizens. So senior citizens, they're often not throwing the wild parties. They're not growing pot in the closet. They're actually good tenants, but they often have a lot of time on their hands, time to look up their rights as a tenant. And sometimes they may have become a little bit of a nudge in the landlord's side. They're holding the landlord's feet to the fire regarding the landlord's responsibilities to their tenants. And this irritates the landlord, but as long as this senior citizen is paying on time, there's nothing they can do about it for it. So one day, instead of paying on the 1st, Joe Sr., maybe he was out of town or the 1st was a holiday, and instead of paying early, he walks in to the leasing office and on the 2nd and says, here's my rent. And the landlord says, nope, not going to take it. And then they convict for non-payment. Some would say retaliation. That's not retaliation. The landlord is not required to accept it. The tenant is in breach. They did not pay on the due date. The landlord may reject that tender and may go ahead and file for non-payment of rent as the cause for eviction. So I always caution attorneys who are counseling tenants that if the tenant has any other non-rent issue that they're dealing with the landlord, and there's some kind of controversy that's going on there, ask them, when do you pay your rent? And if the answer is any other day than the due date stated in the lease, counsel them that they need to start paying on that due date so that they don't give the landlord a really easy way to go forward and evict them. With regard to late fees, in order for a landlord to be able to collect late fees, they have to have a written lease. It must be in writing. And one of the things you want to check in there is a payments clause, an application of funds clause in the lease. Now in Dallas, the two most common leases are the TAA lease, the Texas Apartment Association lease, and the TAR lease, the Texas Association of Realtors lease. Both of these leases have an applications of funds clause. And what this clause states is that with the exception of rent, all other fees and payments are due upon demand. And regardless of any notation on the check or money order, when the tenant pays rent, if those fees and funds, if those other fees or fines are outstanding, the landlord has the right to apply the rent check first to those outstanding fees or fines, therefore causing rent to be late, triggering rent fees, a late fee, sorry. The landlord has absolutely no obligation whatsoever to remind the tenant that he or she needs to pay the late fees. And this is important to note to the tenants as well, because oftentimes we'll have a tenant who is being evicted for non-payment and they come in and they say, I pay my rent every single month. This is ridiculous. I don't understand why they're evicting me. And I will ask the tenant, can I see your rent receipts or copies of your money order? And when I look at them, I know that they have been paying rent late on a regular basis. And I'll ask the tenant, do you pay your late fees? And they'll say, well, they never asked for that, but their lease calls for late fees. There's no duty to remind. What has happened is, and sometimes they're not regularly paying it late. Sometimes they paid it late once 6 months ago, but the landlord applied that month, that payment 6 months prior first to the late fees, causing the tenant to have not paid rent in full, and then has done so subsequently for each month. It's a snowball effect. And finally, the late fees have reached an amount that the landlord is now going to evict. And it's all a result of that one late payment 6 months prior, which has triggered a snowball effect of late fees for the past 6 months, because they never paid. And every time they were paying their rent, the rent was going first to the late fees. So when a tenant says, I'm always paying, I shouldn't be doing it, look at when they're paying. So everything else, what other reasons do tenants get evicted for? The most common ones I have listed here: criminal activity, drug use, damaging the property, having unauthorized occupants, and also unauthorized pets. So um, when a tenant has been accused of a lease violation, ask to look at the lease to be sure it is an actual violation. Then see if a reasonable accommodation could possibly excuse the violation. One example, I've given a couple examples here. One is rent is due on the 1st, but the tenant receives SSDI, so that's Social Security disability income, and gets paid every month on the 3rd of the month, or maybe they get paid on the 15th. Well, HUD has determined that if the tenant's only source of income is that disability payment, then it is a reasonable accommodation. They can request it and ask to move the rent due date to after the day in which they receive their payment. And I usually suggest that if they get paid on the 3rd, you want the due date to be at least the 4th, because that 3rd payment might not come in at 12:01 in the morning. It can come in any point in time. So you want to make sure that the payment actually hits their account in time for them to pay it. But they could ask for a reasonable accommodation to move the rent due date. Or the tenant has a dog, and they're being evicted for an unauthorized pet, but it's an emotional support animal. Or maybe the tenant yelled at a neighbor, the tenant's being evicted for this behavior, but this particular tenant suffers from bipolar disorder and was temporarily off his medication. Now, this is you can only use once, and it's fact specific, but again, a reasonable accommodation could be requested in that. And it's important to note that reasonable accommodations then can be requested even in the middle of litigation. So before there is a final judgment, it does not have to be requested prior to the proposed breach and prior to the landlord filing a lawsuit. So step one is the notice to vacate. The notice to vacate must be an unequivocal demand for possession. It needs to be in writing. And I've put here not via text or email. The statute does not provide for an email or text delivery of the notice to vacate. And there is case law saying that the statute in the property code needs to be strictly followed. I am starting to see, not many, but I'm starting to see the occasional lease that provides for text or email. Haven't seen any case law that supports that because the property code does not provide for that. So I take the standpoint that a text or email, even if the lease says it's okay, is not sufficient for the notice to vacate. To be delivered properly, it needs to be hand delivered to the tenant or somebody older than the age of 16, affixing to the inside of the front entry door, but via mail, or if they can't enter the dwelling because it's either not safe to do so or the tenant has changed the locks. Not safe would be maybe there is an animal that's a dangerous animal inside or makes the landlord nervous. Then they can affix it to the outside door, but only in an envelope that is sealed, labeled important documents, and they put another copy in the mail the same day. So often the failure to deliver the notice correctly can be a procedural defense to eviction. You want to look at this notice and make sure the landlord gave enough notice. If the lease agreement controls here, but if the lease is silent, then the property code gives a default time frame of at least 3 days for the notice to vacate. It may be as few as 24 hours, and I will tell you those two most common leases, the TAA and TAR lease that we see in Dallas, both have the 24-hour provision in that. And so if they've got one of those leases, they can get a 24-hour notice to vacate before the landlord is able to file the eviction lawsuit. You want to make sure it was delivered properly and can be verified. Often we'll see that they'll slip it under the door or put it in the crack of the door, have a tenant take a picture if that's the way that they did it. Usually they've already removed it, and so it's hard for them to do that. Sometimes the landlord will send a maintenance man or another employee who delivered the notice, but that person doesn't show up to testify in the eviction lawsuit that it was correct. Then make sure they waited the proper amount of time that was stated in the notice before they filed the eviction suit. So if they gave a 30 days notice to move out, but filed on the 20th day, they filed prematurely, and that case should be dismissed. The eviction suit itself, the landlord has the burden of proof. If only one party shows up, that party wins by default. Even if you don't see any defenses for the tenant, suggest that they make sure they go to court so that they know what happens and they know whether or not the landlord has won or if the landlord dismissed the lawsuit. Loser pays the court fees and any attorney fees. The court is not allowed to award anything other than possession of the premises and non-payment of rent if that was alleged. So no late fees can be awarded, no repair costs can be awarded. And this is important because a lot of tenants who are evicted have the assumption that the eviction judgment amount, which is only back rent, is all that they actually owe the landlord. And this is often incorrect. They still owe the landlord late fees. They still are liable on the remaining term of the lease. They still owe the landlord any damages that they've done to the property. It's just in the eviction suit, the only thing the judge can award at that point in time, other than possession of the property, is the back rent. So it's not necessarily all the tenant owes the landlord. It's also important to note that not every JP is clear when they evict a tenant. I have been in many a JP's courtroom where it's at least clear to me, and then talking with tenants afterwards, that they don't realize they've been evicted. And here's how the scenario plays out. They're being evicted for non-payment of rent, and the tenant tells the judge that they want to negotiate. They want a payment plan. And the judge looks at the landlord and says, are you willing to do this? And they say, well, maybe, if they can come up with it. And so the judge turns to the tenant and says, well, you'll have to talk to them about, any agreement over rent. And then the judge evicts them, but does not specifically state to the tenant, I have to evict you right now, and I am awarding the landlord possession. Some judges do that. Okay, there are some judges in Dallas. We've got 10 different JPs in Dallas, and there are some that are very clear. Unfortunately, not all of them are. And so many times I have a tenant that comes to me and says, oh, no, 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 I wasn't evicted. The judge just told me I had to pay X. Well, the judge can't get to that X amount unless the judge has first awarded the landlord possession, because that is what the eviction suit is about. It's about who has the superior right to possession. And the judge may not award back rent, attorney fees, court costs, or anything else to the landlord unless that judge has first found in favor of the landlord for possession. So I don't care what the amount is. If a tenant tells you that a judge told them they had to pay a single dollar, that judge has evicted them. That tenant just isn't aware of the fact that they've been evicted. It's also important to note no counterclaims are permitted in an eviction suit. I'm not saying that a tenant may not have other claims against the landlord. It's just they cannot bring a counterclaim in an eviction lawsuit. That would have to be a separate cause of action. So the eviction hearings must be held, as I noted previously, not less than 10 days and not more than 21 days after the lawsuit is filed. On occasion, I have seen the hearing actually scheduled beyond that 21 day. Now, as a legal aid attorney, we're representing the tenant, so we don't usually make an issue about that. But if you're representing a landlord and you've gotten a hearing date that's beyond 21 days, that may be something you want to mention. Landlord must include the description of when and how the notice to vacate was delivered in their petition. If there is an alternative method of service that was used, it must occur at least 6 days prior to the date of the trial. Non-attorneys are allowed to represent in eviction hearings, in the justice court, and in county court if the only issue is non-payment of rent for that. Okay, so know when to negotiate for an eviction. I will say that some, with the exception of non-payment of rent, a lot of non-rent breaches will often come down to a credibility war between the landlord and the tenant. The judge doesn't have a crystal ball, doesn't know who's telling the truth, and is just going to decide who is more credible of the two. Unfortunately, it is not a 50-50 coin toss here. The tenant is usually not on equal footing with the landlord. If both stories appear to be equally credible, more often than not, the judge is going to give the landlord the benefit of the doubt rather than the tenant. So you want to caution tenants that if it's coming out to a credibility war and they don't have any other evidence other than their say so, and it's a he said, she said situation, that maybe they want to negotiate. And you can attempt to negotiate an eviction hold off agreement with the landlord. And hopefully, even if they have to move, that agreement contains a release of liability. They don't get an eviction on their record and they can move forward. Because in a credibility war, the tenant is really rolling the dice in hoping that the judge finds them more credible. Now, sometimes you've got additional evidence. And then it's not just a credibility war because you do have the additional evidence. I had one lady who was accused of she was a tenant, she was the only occupant. The landlord said she had a wild party on a particular night. She actually had her travel documents to show that she wasn't even in town that entire week. And so the landlord really had gotten the wrong unit with regard to the party that had occurred, because she wasn't there. Nobody else lived with her. Nobody else had a key, and she was able to show that she was out of town. And the landlord, in putting on their case, was saying she had the party, she was there. Um, and that really blew it out of the water there when we were able to produce her travel documents and show she wasn't there. So it wasn't just a credibility war in that situation, but a lot of times it is. And we've already talked about counterclaims. Common defenses, okay? Payment of rent, proof of tender on time and in full, or proof that they weren't required to pay. Retaliation is a defense. A landlord may not retaliate against a tenant for taking any legal action that they're allowed to take. So if the tenant calls code compliance because they don't have hot water, they're allowed to do that, and the landlord cannot evict them for having called code compliance. Or if the tenant calls the police because there is a domestic disturbance, they cannot be evicted for taking that legal action. However, it's important to note retaliation will never be a defense to non-payment. A lot of times I have tenants that say, oh, the only reason they're not going to let me pay late or do a payment plan is because they don't like me and they're retaliating. No, it's not a defense to non-payment. Can't use it there. Defective notice or no notice, the failure to prove up the delivery of notice, illegal discrimination can be a defense, novation, not the correct party. Now, we see this more often than you could think. What often will happen is it's often a single family home that's being rented. And the owner of the property has taken title of the home in an LLC, but they file the eviction as John Smith versus Tenant. Well, they don't have title in as John Smith, so they're not the correct party. Also, I put a note here, check the Secretary of State website. So if it is an LLC or a corporation that is filing, make sure they're in good standing. If they're not in good standing with the Secretary of State, then they're not able to file a lawsuit until they are in good standing in their name. So that's always a good quick thing to check. You would be amazed at how many landlords are not in good standing with the Secretary of State. Title at issue, unclean hands, filing prematurely, and then we're going to talk later about domestic violence. We'll get into that. And then if their franchise fee is unpaid, you want to check that as well when you check the Secretary of State website, because that may be a defense to the eviction. Eviction appeals are de novo. So the tenant does not need to have a reason or ground for appeal. The Justice of the Peace Court is not a court of record, so they get a de novo appeal to the county court. It's the same issues, but now all of the rules of evidence apply. So in the Justice Court, if you're not familiar and haven't tried a case in Justice Court, the rules of evidence apply only if the judge chooses to apply them. I will say there are some judges who have a double standard in that they will apply them to the attorney if there is an attorney on the case, but will not necessarily apply them to the other party if they are pro se. So it can be kind of frustrating. Some evidence that would not make it into county court can make it into the justice court. So sometimes you want to appeal to county court just because you know you can get it tossed in county court where under the rules of evidence, but they let in hearsay or something else in the justice court. Landlords that are LLCs or corporations must have an attorney on appeal unless it's non-payment of rent. And we get cases dismissed for this all the time. When the county court receives the appeal, they will send a letter out to the landlord that clearly states if you are an LLC or corporation, you must have an attorney. Some of these folks will show up without an attorney and ask for, as soon as we mention it, they'll ask for a continuance. The judge will look at us if we're representing, and my response is always the same. I'll look at the judge and I'll say, Your Honor, your court gave them notice that they needed to have an attorney for this hearing today. They've ignored the notice, and no, I will not agree to a continuance. I'm asking for a dismissal, and I get it. So you do want to make sure that you check and don't proceed if if they're an LLC or a corporation and they did not show up with an attorney, ask for that dismissal. The county court judges will give it to you. Appealing can buy time to negotiate. So often when the tenant is, and this is especially true in non-payment of rent cases, the tenant can't get payment before the justice court eviction, but maybe they can work something out in the time for appeal. Timeframes for appeal in Dallas County on average are about 5 weeks. Okay. Could happen as fast as 3. That's very rare. Sometimes it might go 6 or 8 weeks, but the average time between filing the appeal in the justice court to county and having a county court hearing is about 5 weeks. So you've got that window of time to see if you can negotiate. Often if the tenant appeals but surrenders the dwelling before the county court hearing, the landlord doesn't show up because they've got possession. If they don't show, the tenant, always caution your tenants to show up, make sure they get a dismissal. The case will be dismissed. Now they don't have an eviction on their record for it. Okay, so that's an overview of the eviction process. I'm going to move into talking about the CARES Act right now. Yes, the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act, is still around. It's important to know that the CARES Act did not have a sunset provision when Congress passed the CARES Act. So while we're often thinking about the fact that all of the moratoriums that existed for evictions and whatnot have gone and those have ended, one of the provisions of the CARES Act is that some landlords need to give a 30-day notice to vacate, in addition to whatever notice the Texas law provides, if the eviction is due to unpaid rent. For which landlords? Okay. Protected tenants are those who rent from a landlord who has a federally backed mortgage loan through HUD, the VA, the USDA, Fannie Mae, or Freddie Mac. They are protected, plus any tenant in public housing, in low-income tax credit housing, who is on a project-based Section 8 or Housing Choice Voucher Program or a rural voucher program. So if your tenant falls under this provision, the landlord has to give them a 30-day notice to vacate if the issue is unpaid rent. Now, if they're alleging a non-rent breach, they can give the 3 or the 24-hour that the TAA and TAR lease provide for. But for non-rent breaches, they have to give 30 days. How do you figure out if the landlord falls under the CARES Act? This can sometimes be difficult. Typically, if the tenant is in public housing, tax credit housing, or Section 8 or a voucher, they're going to know and they can easily tell you. What becomes more difficult is whether or not the landlord has a federally backed mortgage loan. I'm including here 2 links to where you can look that up. Unfortunately, since the pandemic, these links, the second one, the Texas Department of Housing and Community Affairs, that link stays updated. The first one, they try to update it, but it may not be updated or include all of those properties. Sometimes you can do a little digging into the deed records, And you can see from the deed of trust whether or not it's a federally backed loan. If it is, or you believe that you have evidence that it is, bring it up, bring whatever evidence you have to the hearing. The burden then shifts to the landlord to prove that they do not have a federally backed loan for that. Now, I will say that there are some justices of the peace who don't think the CARES Act applies anymore. And that is incorrect for that. And they don't think that because during the pandemic, the Texas Supreme Court required the landlords to add additional information when they filed their petition with the court. And they were requiring to check about the use there during the pandemic. It was about the moratoriums, there was rental assistance available, and the landlord had to check all of these boxes. That is no longer required with the petition. And one of the boxes was the CARES Act. Because that's no longer required, there are some justices of the peace who think that the CARES Act no longer applies, even though it has no sunset provision. And we certainly argue that the CARES Act does still apply until or unless Congress chooses to sunset it. Okay, other common issues that we're going to be talking about moving forward with lockouts. In order for a landlord to be legally permitted to lock a tenant out, the tenant must be delinquent with the rent. And then the landlord is required to give written notice of their intent to lock out the tenant and notice of the time of lockout. Now, that notice needs to be delivered at least 3 days prior to the lockout if it's hand delivered, 5 days if by mail. The notice needs to tell the tenant how much rent they owe and where they can go to pay it. And if they don't pay, when they're going to be locked out. No door removal is allowed here. Okay. Yes, we have had landlords who have physically removed the entry door. If they have physically removed the entry door, it is still considered a lockout. And the remedy, which we'll talk about on the next slide, is a writ of reentry. And I've got a good story with that one. I had a clinic, and it was a landlord tenant clinic in which myself and a group of volunteer attorneys were participating. But that particular evening, Professor Spector of SMU Law had attended the clinic with several of her students. And there was one volunteer attorney who met with a tenant whose door had been removed. And this volunteer attorney was trying to explain to the tenant that she needed to go request a writ of reentry. This tenant thought that that attorney was as dumb as dirt because she kept telling him, I don't have a door, so I can enter. And he just couldn't get her to understand that this was still the remedy. So he came and he asked if I would go talk to the tenant. I went to talk to her. She still didn't believe a writ of reentry. So thinking that nobody could have more authority at the clinic than a professor of law, I went and asked Professor Spector if she would please go and speak to this particular tenant. She did. She explained the writ of reentry. Long story short, no, the tenant didn't believe us and left that clinic very frustrated that we wouldn't help her because she could already enter. So if the door's removed, it's considered a lockout. How does the tenant get back in? Well, if the landlord has done it properly, they should put a notice this time on the front of the door stating how they can be reached 24/7. When the tenant calls and requests that they be let back in, the landlord is required by law to let the tenant back in within 2 hours of their request. And yes, they have to let them in whether or not they pay the rent. Now, you may be thinking, why would the landlord bother with a lockout if the law requires them to let the tenant back in within 2 hours, even without the rent? And I will tell you my theory on why landlords still do this, two reasons. Number one is often tenants who are not paying the rent have also stopped communicating with the landlord. So in doing the lockout and showing up to let the tenant back in, the landlord now has an opportunity to have a face-to-face conversation with the tenant. And can that landlord ask for rent at that time or see if they can work something out? Yes. He still has to let them in, but he may ask about the rent and have that conversation with the tenant. The other thing is there are a significant number of tenants who once have been locked out simply leave. That's it. They don't ask to be let back in. They just leave. And if they just leave, they have saved the landlord the time, money, and trouble of going through the eviction process. So that's why landlords will still use the lockout provision. They are prohibited in tax credit properties in public housing, and the remedy is the writ of reentry. Writs of reentry, um, I often tell tenants, go file that writ of reentry when the courthouse opens at 8 or 9 a.m. in the morning. If they file it first thing, most JAPs will attempt to have a hearing that afternoon. If they cannot get a hold of the landlord, the law allows the justice of the peace to have an ex parte hearing with just the tenant, and the judge can issue a writ of reentry that can then be enforced by a constable. So there are statutory penalties for the landlord to failures to follow the lockout provision. So in addition to filing a writ of reentry, a tenant may also file a claim for an improper lockout. Now, the statutory penalties are actual damages. So if the tenant ended up having to spend a night or two in the hotel, actual damages would be that a hotel bill. 1 month's rent plus $1,000 attorney fees and court costs. If a tenant owes rent, look at how much they owe plus that $1,000. Often you can start negotiating a reduction or a waiver of rent when the landlord realizes they have violated the lockout provision, and we've got some statutory penalties here. So moving on to what happens when the landlord shuts off the utilities and there's an interruption in utilities. Generally speaking, a landlord may not cut off a tenant's utilities for any reason other than a bona fide repair or emergency. And this includes non-payment of either the utility bill or the rent. I will add a caveat here that if a written lease provides for it, then a disconnection or interruption may be allowable. But if a landlord has done this, open up the Texas Property Code to section 92.008H. There are very specific steps and criteria that the landlord must follow when they do an interruption or disconnection for non-payment of the utility bill or rent. And it is extremely rare that the landlord gets this right. I will note here that when we're talking about the landlord shut off, we're talking about landlord provided utilities. If the tenant has their own account with the utility company, so TXU, Encore, Reliant, whatever it may be, and they don't pay that bill, can the utility company shut it off? Absolutely. They can shut it off for non-payment. This is just for landlord provided utilities. The legislature largely took away the landlord self-help remedy here. With the exception of that particular property code section, they made it a very onerous burden that the landlord has to follow very specific steps. And very, very rarely do the landlords get this right. So what happens when they get it wrong? We file for a writ of restoration, which is very similar to the process of a writ of reentry. It can be heard on an emergency basis. Typically, the judges will hear it the same day if they file first thing in the morning. And the writ entitles the tenant to the immediate and temporary restoration of the utility service. filed in the justice court sworn complaint. Landlord is entitled to a hearing, but has to request one within 7 days. If they don't request it, then the court can enter a judgment for court costs against the landlord that does not request a hearing for that. And they may hold a landlord in contempt who disobeys their order to restore the utility services. So moving on to landlord liens. A landlord can only exercise a lien if they have a written lease with the tenant. So no oral, any landlord who is operating under an oral agreement, they do not have the right to do a landlord lien. The lien must be written in the lease and it must be noticeable. It must be in bold print or underlined in order to be valid. Why? Because it's the only warning the landlord has to give to the tenant. They do not, unlike the lockout, where the landlord has to give advance notice of the lockout. And I have seen landlords give advance notice of a lien, not exactly sure why they would do that, but they're not required to. And why not? Well, let's think about it. Let's say I'm your landlord, you didn't pay me rent this month, and I say to you, hey, you didn't pay me this month, so tomorrow I'm going to come over and exercise this lien. I'm going to take your big screen TV. How many of you are actually going to have that big screen TV sitting there waiting for me to come and pick up at 3 o'clock tomorrow? Probably none. So that's why the only warning they're legally required to get is the provision in the lease agreement that is in bold print or underlined. Now, when the landlord comes to exercise the lien, they must do so peaceably. So they typically will choose to do it while the tenant is out and not present. They are required to create an inventory lease. They can only charge storage fees if they are mentioned in the lease agreement. There are certain property that is exempt that the landlord may not take. So if a tenant tells you that a landlord has exercised a lien, you want to see a copy of the inventory list, and then you want to open up Texas Property Code Section 54042 and check that inventory list against that exempt property list. Now, examples of exempt property are food, medications, school supplies, work tools are exempt property. Difference between a tenant's hobby and their work. So if a tenant's hobby is woodworking, then all of their woodworking tools are fair game. The landlord can take them. However, if the tenant is a carpenter by trade and it's how they earn their living, then those are work tools that are exempt. The landlord may not take, there's a certain number of tables, couches, beds that they can't take. Also, the landlord may not take children's toys. However, the property code is specific here. It says toys with which adults do not play. So when we're talking about toys, we're talking about Barbie dolls and Matchbox cars. The Nintendos, the Wiis, the PlayStations, all of those video games are fair game. Why? Because there are a significant number of adults who play those games also. So what is the landlord going to take? They're usually going to go after those items. They're going to go after the TVs, the video games, the electronics, the high ticket items for it. Why? Because tenants want them back. How does a tenant get their property back? They pay the rent. If not, the landlord is allowed to have a sale and sell their belongings at auction in order to recoup the rent. There are statutory damages for a landlord taking exempt property and not giving it back. Now, sometimes the landlord can't tell which is exempt. An example here would be a laptop. They won't know whether or not that is a work laptop that their work provided or is a tenant's personal laptop. So if they take the work laptop, the tenant just needs to produce evidence that this is a work laptop provided by their employer, and the landlord should turn it over. But if they take other items, like I have seen landlords take medication, we've had landlords take insulin from out of the refrigerator of a diabetic. We've had landlords that have taken wheelchairs from disabled tenants. Unfortunately, with landlord's liens, unlike the interruption of utilities or lockouts, there is not an emergency remedy. There is not the ability to get a writ very quickly if they take the exempt property. So what do? I suggest that if they've taken something, especially like medication or a medical device like a wheelchair or oxygen tank, yes, we've seen landlords do that, call the police. Often they will show up, and when the police, they're not going to get involved with the other items, but for things like medications and medical devices, most police officers, when they show up, will tell the landlord, give it back, give it back right now, or we'll arrest the landlord for taking the property, and they'll consider it theft. So that is really the only emergency remedy a tenant has in this situation. Otherwise, they can file suit for an improper lien. There are statutory damages for willful violation, but that suit is going to proceed just like any other small claims lawsuit in the justice court. There's no emergency remedy. And again, landlord liens are prohibited in both tax credit properties or public housing. Okay, so I want to talk about victims of domestic violence. Okay. Um, if the tenant is an eviction, is being evicted, and they are a victim of domestic violence, usually the landlord does not say, I'm evicting them for domestic violence. They'll say that they're being evicted for criminal activity, um, typically meaning that the victim called the police, and often there was an arrest made. And so now the landlord is trying to evict them. If they are being evicted because that was a family violence or domestic violence issue, that is a defense to the eviction. Um, if the person who committed um, the offense is an occupant or co-tenant, you can assist the other tenant with getting a protective order with a kick out provision that kicks out the offender. Also, they want to document the family violence that occurred against the tenant, the co-tenant, or the occupant, and they can do it in several different ways. One is with a statement from a licensed healthcare service provider who examined the victim, or a licensed mental health service provider, or an advocate as defined in the family code who assisted the victim. So several years ago, they changed it. It used to be that they had to go and get a protective order against the offender, and only in a protective order and injunction provided the victim with the domestic violence defense. Now it's no longer the case. They just need a document testifying from one of these professionals. So also domestic violence victims, they can terminate their lease on domestic violence grounds if they choose to. So in the first scenario, we have them using it as a defense to being evicted by the landlord. In this scenario, we have someone who has been a victim of domestic violence who is not being evicted, but wants to terminate their lease because the offender either lives with them or knows where they live. So they have to give the landlord notice. It's a 30-day notice is required unless the violence is committed by a co-tenant or approved occupant of the dwelling. So if it's someone who lives with them, they can give immediate notice to terminate the lease to the landlord. If it is from someone outside the home, then they have to give a 30-day notice. When they present the landlord with this notice, they have to have one of the following: a temporary injunction, protective order, or And we're back to the documentation of family violence against the tenant or occupant. And if they present this to the landlord is required to let them terminate their lease without further liability. Now, if they owe back rent, they still owe that to the landlord, with one big exception. The legislature decided that victims of domestic violence were really entitled to know their rights. And they require all landlords to put a notice in written lease agreements that if they are a victim of domestic violence, that they have these rights. So if the tenant has a written lease and that written lease does not include a provision notifying the tenant that if they're a victim of domestic violence, that they have these rights, then if that tenant owes back rent, that rent is waived. The Texas legislature decided to make that the penalty for a landlord who failed to inform a tenant that that tenant had this right. So if you have someone, now I'll tell you, if they've got a TAA or TAR lease, it's in there. But if the landlord created their own lease, and a lot of landlords who just have a couple of properties will do that, they'll download it from the internet. They don't have it, and that tenant tells you, look, I owe back rent. Check that lease out, because if the notice is not in there, they don't owe the rent. They can terminate. They're relieved of further liability, and they're also relieved of the liability of that back rent. Vacating. They do have to vacate to be freed from liability. So once they give the landlord notice and say when they're vacating, they're still liable for rent up until the day that they vacate. So they've got to vacate to be freed. And then again, landlords who refuse to comply, they are hit with some statutory fines, which is the penalty of 1 month's rent plus $500. And you can go after them for attorney fees as well. Okay, repairs. A lot of tenants seek assistance for repairs. In Texas, a landlord has absolutely no duty whatsoever to repair the property unless the tenant is current on rent. The tenant must be current on rent in Texas in order for the landlord to have a duty to repair. Now, a lot of tenants will say, oh, it's not up to code. Well, that's between the city and the landlord. The city and code compliance can fine the landlord as much as they want, and they can do as many inspections as they want. The landlord does have a duty to the city to bring it up to code or continue paying those fines that the city assess. But with regard to their duty to the tenant, they have a duty to that for items that affect the health and safety of the occupants of the dwelling, as long as the tenant is current. So you've got to ask your tenant, are you current with rent? Then the landlord has that duty. They need to give the landlord notice of repairs, send it in writing. We at Legal Aid of Northwest Texas have a repair packet that includes the sample letter. And as you note, I said letter. Why? Because the code says a letter. And it's important to note that a lot of landlords have portals where tenants can request repairs or work orders. The portal emails and texts are not necessarily sufficient to cover the writing provision of the property code unless specifically allowed for in the lease. So I tell tenants who have told me that they've emailed the landlord, that they've texted them, or they put it in the portal, or they've submitted a work order, and a lot of landlords, they play with semantics and they will say, well, that's a work order, not a repair request. So the code says write a letter, send it, preferably certified mail return receipt requested, or any of the other tracking forms that the post office allows. If they send it via one of the tracking methods for delivery, then the landlord has 7 to 10 days to respond. If they fail to respond, the remedies are triggered. If they did not send it via a tracking method through the post office, then they have to make a second request and wait another 7 to 10 days before any of their remedies are triggered under the property code. Their remedies are, there's three here. I really say there's only two. Terminate the lease. Now, if the tenant is terminating the lease, you need to advise them that they need to terminate in writing, preferably send it certified mail, and that they need to keep a copy of their lease agreement, their request for repair, and that termination notice for 4 years. Um, a lease is a contract. You can be sued on a contract for 4 years in the state of Texas. If the landlord comes after them for terminating in the middle of their lease, they're going to need to be able to show that they had the legal right to terminate. So they need to keep their records. All they have to do, keep that lease, the request, the termination notice in an envelope marked do not destroy for 4 years, and they'll have that to defend if the need be. The other option, if the tenant wants to stay, is to file for a writ of repair in the justice court. When they file for a writ of repair, these are expedited lawsuits. Typically, the justice court will have a hearing within 10 business days. So within 2 weeks, they'll get to go in front of a judge, make their case, and argue for a writ of repair that the judge can order the landlord to make the repairs. And here they can ask the judge to abate the rent. The tenant must continue to pay the rent in full. The property code does not allow them to stop paying. So if they want an abatement or a reduction in rent due to the failure to repair, they need to file for a writ of repair, and they need to get the judge to do that within the writ and make that order. Otherwise, they need to continue to pay rent in full throughout the process. Now, if you're familiar with the property code and you've looked at it, you'll see that there is a repair and deduct provision. Don't advise tenants to do that, not unless you, as their attorney, are going to walk them through the process. That particular process is only for a very narrow set of circumstances, such as lack of potable water or sewage. And it is a very onerous process the tenant must go through. So first, it has to meet those narrow set of circumstances. Second, the tenant, part of that process, needs to notify the landlord. If the landlord fails to respond to their repair request, then they need to notify the landlord they're going to do the repairs themselves. They need to get at least 3 multiple bids, and they need to be hand-length transactions. So if the tenant's brother-in-law is a plumber who's going to do it, that doesn't quite qualify. They need to let the landlord know, give the landlord time to respond. This process is going to take at least twice as long as the repair suit in the justice court. And I can tell you, at the beginning, Kristen said I've been with legal aid since 2005. I'm going into my 20th year with legal aid, and I can tell you exactly how many tenants during that 20 years have followed the repair and deduct process correctly, and that number is 0. I have yet to see a tenant without the guidance of an attorney successfully follow the provisions in the property code for repair and deduct. And what almost always inevitably happens is not only are they liable for rent, they end up getting evicted for rent, and the landlord can go after them for making unauthorized things to the dwelling. So please, unless you're going to walk them through it, don't advise that. Something to note here is many tenants consider the move-in condition form to be repair requests. It is not. It's merely a statement of the condition of the property at the time in move-in. If they notice things that need to be repaired at that time, they need to make a separate repair request. I noted that work orders, landlords play with semantics. They do not necessarily consider a work order to be a repair request. Logically, that follows, But sometimes they work around that. So the best practice is to always submit the work order, but also make the request via letter. Um, Heat and air. Okay, it's pretty cold today, and we get pretty hot in the summer in Dallas. Heating and air conditioning regulations for tenants are not covered under the property code, but under individual city codes. So if a tenant says that their heater air is not working properly, you want to look up the city code for the regulations to see if the landlord is in violation. I've given you the example of the city of Dallas codes. Um, in the city of Dallas, it's maintaining a room temperature of at least 15 degrees cooler than the outside temp, but in no event higher than 85 degrees. So we know in our summers, it can get really hot. It often gets over 100, but if their AC is cooling to 85, it is within the city code, and that is considered sufficient. Same thing for heating, no event lower than 68. We don't see as much issues with that as we do with the 85 in the summer. Some tenants are really frustrated when they're told that 85 degrees is considered sufficient. Okay. From the TAA lease, air conditioning problems are normally not emergencies. Um, and it's important to note the law does not provide for emergency repairs. That we don't get to do a writ for repairs quickly, other than filing the repair lawsuit. We don't get that 24-hour expedited process that we get for lockouts and reentries. Um, Often the people that have the biggest hammer to expedite repairs are code compliance with the city. Um, and with regard to air conditioning, if you get the right code compliance officer to come out, they will hit that landlord with a hammer of daily fines until they have remedied the condition. So with heat and air, that if it needs to be expedited and the landlord is not responding, it's time to call code compliance. Okay, we talked about emergencies, loss of use when repairs happen. Um, Sometimes the tenant needs to temporarily move out. They don't get an abatement in the rent unless the landlord chooses to do that. The landlord is not required to put them up in an alternative dwelling. This is why it is always recommended that tenants have renter's insurance with a loss of use clause. Similarly, landlords are absent negligent or intent are not responsible for the personal property damage or loss suffered by the tenant. Renter's insurance is really cheap. Even our legal aid clients can often get it for $10 or $12 a month to cover their property. So you do want to encourage tenants to get renter's insurance. Okay, Fair Housing Act violations. Fair Housing Act prohibits discrimination in the following categories of race, color, religion, sex, national origin, familial status, and disability. If a tenant believes they have been discriminated against, you can give them either the Texas Workforce Commission or the Fort Worth Regional Office to file a complaint. If they are a city of Dallas resident, not county, but city of Dallas resident, the city of Dallas also has a fair housing office, and they can make a complaint with the city of Dallas Fair Housing Office. If you suggest they do so, let me give you a little tip, and I believe they still do that. The city of Dallas will do an investigation for every full and completed complaint that they receive. I always tell tenants if they're going to file with the city of Dallas, go down in person and make sure they fill out everything. If they skip a section on the form, sometimes they don't think it's applicable. You need to tell them put NA for not applicable, because the city of Dallas, if they skip something, that's not a completed complaint. It does not automatically get investigated. So they need The Workforce Commission and HUD, I haven't heard that about, but the city of Dallas, that complaint needs to be filled out in its entirety without skipping anything in order to trigger an investigation. Okay. Reasonable accommodation. A denial of a reasonable accommodation does equal discrimination. Um, Reasonable accommodation are in their rules, practices, or services may be necessary for a person with a disability. Um, so, a person with a disability is an individual with either a physical or mental impairment that substantially limits their ability to engage in more than one life activity. They need not be on disability benefits to be regarded as having such an impairment. They may make the requested change orally, but it's difficult to prove up an oral request. So I always advise that they make their request in writing. If their request is something that is not obvious, okay, so obviously a blind person will likely need a fire alarm that sounds, and a person who's deaf needs a fire alarm that has lights up for it. An individual in a wheelchair clearly needs a ramp. But some disabilities are not obvious. If it's not obvious, the landlord is permitted to ask for evidence of the disability. They don't need the medical records, but a simple doctor's note will suffice. I always suggest that if it's one of those non obvious requests, that when they make the request, go ahead and attach the doctor's note. Don't wait for the landlord's request. If the landlord fails to make it, they can go ahead and make a fair housing complaint. Federal subsidies. I know I've just got 5 minutes left, so I'm going to go real quick here. We're talking about public housing, subsidized housing, vouchers, veteran affairs. Generally, there are more protections, but there are also more obligations on both parties' parts. So I'm very briefly put up a quick synopsis here. If you find as a private attorney that you're dealing with subsidized housing, you contact Kristen or Kathy with DVAP, and they'll put you in touch with one of us to guide you through the process. But public housing, the landlord is the public housing authority for it, and they agree to evict only in accordance with federal rules. The notice to vacate is now 10 days notice of proposed lease termination as opposed to the Texas 3. Tenants often have the right to request an administrative hearing or meeting with the landlord to address issues. However, they usually are limited to 10 days to make this request for it. So if you don't know what to tell a tenant yet, and you're not exactly sure what type of subsidized housing they have, as a private attorney, you can never go wrong with advising them to go ahead and make the request for an administrative hearing. And to do it within the 10 days. Now, certain circumstances, such as criminal activity, they don't necessarily have the right to the grievance process, but sometimes they're given it anyways. So you can never go wrong by advising them to go ahead and make that request. Section 8 vouchers, there you're dealing with private landlords that are subsidized by a housing authority. So the lease agreement will control unless there's a conflict between the lease agreement and the housing assistance payment contract that it will control. So there's really two contracts in this scenario. Anytime a private landlord wants to send a notice to vacate and begin the eviction process against the tenant, they must copy the housing authority at the same time, or this will be a procedural defense to the eviction. And a landlord cannot evict a tenant for non-payment of the housing authority's portion, only the tenant's portion. Some tenants have a zero portion. Most tenants have a portion of the rent, depending upon their income, that they have to pay. The tenant needs to be advised that they need to continue paying their portion no matter what, because if they're in compliance, the landlord cannot evict the tenant for the failure of the PHA's failure to pay. Okay, that was a quick overview of subsidized housing. There's my contact information here. As I did say, Chris, DVAP will send out the PowerPoint after the presentation. I'm going to stop sharing. For those of you that want to stay online and ask questions, I am more than happy to take them now. Let me see. It looks like there's 3 questions in the Q&A. So let me see. What do you recommend we do to help clients whose apartment management refuses to keep common areas clean of dirt and trash, enforce dog on leash policies, already sent a demand letter? Okay. I would suggest that this is an issue for code compliance. If the common areas are not clear of dirt and trash, then they may be up against some safety violations for ingress and egress, especially if there were a fire. You want the firemen to be able to get to the individual units. So I would look at code compliance, and then dogs on leashes, that is a city ordinance. So if a dog is not kept on a leash, they can report that to the city. And the owner of the dog can be fined. And code compliance may, I'm not sure if they were able to fine the landlord on those if they don't catch them. But they should definitely go ahead and call the city and call the police for fines of dogs that are not on leashes. That's a city ordinance. How likely is one to prevail for a negligent security claim against an apartment complex after theft or vandalism in the parking lot? Not likely. Okay. You're really going to have to show negligence or intent. Generally speaking, a landlord is not liable for the actions of third parties, and this includes neighborhood issues and crime. So if a tenant's car is vandalized in the parking lot, if they're mugged in the parking lot, and this has taken place by a third party, the landlord generally has no liability. You're really going to have to come up with a but for, negligent claim there. I can't advise you as to how successful the negligent claims are because at Legal Aid, we do not do torts such as negligence. For that, I can just say that generally speaking, the landlord is not liable for acts of third parties. Next question, recognizing that JP courts don't have jurisdiction over title disputes, but I've seen several cases where a fraudulent deed was filed in the property and the rightful owner or occupant was then evicted by the fraudulent deed holder. Notable, the cases I've seen involve the same attorney in the same JP court. That said, what can a tenant attorney do to deal with the issue aside from fighting title issue in district court? You've got to fight the title issue for it. The justice of the peace is going to presume that what is in the deed records is accurate if it has not been challenged. So you need to show that there is indeed a title dispute. And if there's an actual deed, they're generally going to assume that that deed is valid if there has not been a cause of action to get that deed set aside and prove that it is indeed fraudulent. When we're not talking deeds, sometimes I have seen competing affidavits of heirship that say 2 different things. That the JPs are a little bit more amenable to tossing aside because they don't know which one it is valid. But if there is a title issue and you've got a fraudulent deed, you're going to have to bring a cause of action in district court in order to get them to recognize that this title is indeed being challenged. Name of a pro bono attorney in Montgomery County. I can't give you a name of a pro bono attorney in Montgomery County. I would check with the local bar association there. You can also check, I'm not sure where Montgomery County is, but there are three big legal aids in the state of Texas. There's Legal Aid of Northwest Texas, Lone Star Legal Aid, and TRALA, Texas Rio Grande Legal Aid. And they can apply with the nearest legal aid office there. And most legal aid offices, if they can't take the case, have connections with various pro bono attorneys. So they should be able to give some more direction. Next question. Could rent be withheld if there is no hot water over weeks or a period of time? No, rent may not be withheld for that. But one thing that a tenant could do in that situation, um, and this is a lot of tenants aren't, willing to do this, but a lack of hot water um, for weeks at a time when the landlord has been given notice could be considered a constructive eviction. Now, in order to have a claim against a landlord for constructive eviction, the tenant must move out. So often I have tenants who say, I'm constructively evicted. And I say, well, where are you living? And they're still living there. Well, by definition, they have not been evicted. So the failure to provide hot water, the failure to provide water at all, or potable water, the failure to provide utilities, if the tenant moves out after notifying the landlord and there's a protracted period of time there, then you want to look at the elements of a constructive eviction claim. But again, they won't have it unless they move. So that if they want to stay, they need to file a suit for repairs in the justice court. If the no parking paint on the ground is chipping and barely visible, failing to properly notify guests and renters that the area is not safe for parking, what remedy could be applied for individuals whose vehicles were towed from the apartment complex? Okay, so there are some parking rules, and with the towing that they need to make sure that they are visible to an ordinary tenant or guest. If it's chipping and barely visible, you want to take pictures of that and you can challenge it in court. You can bring suit for that. Usually we at Legal Aid, we have standard letters that we'll send out for reimbursement if they've already gotten already gotten it towed and they've gotten it out of the impound. If it has been towed and they can't afford to get it, then what they want to do, and this is the towing laws, they usually only have, oh, I should know this off the top of my head. I want to say it's 14 days in the administrative code to file a to file challenging the towing in the justice court. And then they can get the judge to determine whether or not that towing is appropriate. But the clock is ticking, and it's no more than 14 days. It may be as short as 10, but I believe it's 14 days. If you message Maricela or me directly when you get my email address, I will send you the code sections for that and get you the exact dates for it. Okay, any other questions? I think that was the last one. I see there's two messages in the chat. Oh, that's just you, Maricela. Okay. Did somebody add a final question? Oh, just thank you. Well, you're welcome. As I said, Maricela will be sending out the PowerPoint. The last slide has my contact information. Feel free to give me a call or shoot me an email if you have any additional questions. Thank you all for attending today. Thank you for your time.
Thank you, Marianne. And then I did include the MCLE course code in the chat. And if you need that number, that is 174-267-644. Again, that is 174-267-644, and it'll be emailed to you following today's presentation. Again, thank you all for being here, and we appreciate Marianne for your wonderful presentation. Have a good rest of your afternoon.
Bye-bye.